It looks like both sides are here on that case. Mr. Sykes, you're up. Thank you. You can begin.
Your Honor, I represent the appellee in this case.
Oh, I got it backwards. Sorry. Sorry about that.
I'm happy to go first, though.
No. I won't start the clock until Mr. McKay is ready. But thanks for answering me.
I'm ready, Your Honor.
Ready.
May it please the court, my name is Scott McKay and I represent the appellant Jonathan Wysaski in this matter. I'd like to reserve 5 minutes of my time if I may.
All right, you got it.
Thank you, Your Honor. 80%. 80% interest is why we're here today. Stated as a decimal rate, not stated as a percentage, payable daily. That's the loan. 80% interest.
Where did that 80% come from? Another state?
Yes, it comes from the loan documents. It's written as a decimal in the loan documents. Now, your question is, why is that allowable? They put a Wisconsin choice of law provision in the loan documents. Wisconsin apparently doesn't have a usury clause. Florida does.
But they signed a contract in Florida, but they incorporated Wisconsin law.
Is correct. They signed it up.
And you don't like that because of a public policy concern?
Well, there's two reasons we don't like that. So public policy is a piece of it, but there's a test here. There's an or test. So we're talking about contractual choice of law. That's where it comes from. So let's remember that we have a Florida piece of property, a Florida note, a Florida mortgage, and a Florida guarantee that somehow tries to pull Wisconsin law into it. Now, contractual choice of law provisions, they're not automatic, but they are presumptively enforceable. That's true. Presumptively enforceable, which means there is a rebuttable presumption to those. A party can overcome that presumption by doing one of two things: by showing that public policy or by showing that a provision contravenes strong public policy of Florida. That's one way, or by showing that it is unjust or unreasonable. And that comes from two cases. That's either the Viridis case or that comes from Friedland. We argued that before the trial court, that this is an either or test. So there's two ways to rebut it. Show that the provision contravenes the strong public policy of Florida, and we'll talk about that, or show that the provision is unjust or unreasonable. There's two ways to go about it. Now, the trial court refused to consider this an either or test, and I pushed the trial court on that point. I requested specifically that the trial court do what it was going to do, but I requested that they make a finding that this was unjust or unreasonable. And you'll see from the transcript that the trial judge did not want to do that and noted, and I quote, "The issue is certainly well preserved for appeal." Now, whether or not this provision is unjust or unreasonable is a question of fact based on a variety of circumstances that would not be appropriate to be heard on a motion for summary judgment, which is how we got here. So I would respectfully suggest that the trial judge in this case did not view this as an either or test, as there are two ways to go about it. And I would suggest that certainly the or component of this, that is unjust or unreasonable, is something that the trial judge should have considered. Now, the appellee's brief acknowledges that this is an either or test. Their thought is that there's just no guiding law on how we figure that out. But there's no debate that the case law provides the or.
Well,
So
we're dealing with the choice of law provision, counsel, and I'll cite to the argument you made at page 616. When you asked the judge to make findings, you said, "I would like to at least address that because I don't need record evidence. We know that the interest rate is 80%, and that's the legal argument I'm making to you. And that charging it is unjust and unreasonable. So your unjust and unreasonable argument is the 80% amount, correct?"
Correct.
Okay,
But
so let's start with this transaction. It really isn't a Florida guarantee because Mr. Wysaski is a very educated, sophisticated businessman with an accounting degree who's very, very successful on the Chicago Board of Trade. He gave his friend $500,000 to operate this car wash without even doing any diligence to find out if he had any experience whatsoever. Now, according to the depot, he's probably going to sue him. But then at the outset, your client says this is a forgery. I did not sign it. yet says the Wisconsin venue of choice makes sense. Then when he's taken his deposition, he can't recall anything, but when the recording of the call with the WBL agent is played, he goes, well, that sounds like me. Well, in that particular calling, I can point it out in the record, your client asked twice, what is the interest rate? And your client says at 423, just one more time, what is the daily interest payment until July 1st? And she told him again, 398, and he said, okay. And then he set up having a notary in his office. So you're portraying this case as if we have a helpless, unsophisticated individual consumer versus a sophisticated, nationally known bank that buys loans. We have an Illinois resident who decided to guarantee a loan that was bought by a New York company, and the New York company is subject to Wisconsin law, just like your client is. So take me from there. Where is it unjust and unreasonable now that we've laid the playing field?
Certainly. You know, what we're getting into is whether we have a sympathetic enough client on this situation, and I would urge Your Honor that that's not the test. The question is, does it contravene a strong public policy, or is it unjust or unreasonable? Now, do I wish I had a more sympathetic client? Sure, I wish I did.
Well, it's not so much sympathetic client because the Florida Supreme Court, if we reverse you, we are creating new law in contravention with the Florida Supreme Court that says few courts that rely on public policy exception and usury choice of law situation invariably are dealing with an individual and often a consumer borrower. We do not think the mere fact that there exists in Florida usury statute, which prohibits certain interest rates, establishes a strong public policy against such conduct in this state where interstate loans are concerned. That's the Florida Supreme Court in 1981.
Sure. You're talking about public policy, Your Honor, and I've never debated what the statement of this court and the Florida Supreme Court say on public policy. There is not a strong public policy, says our Supreme Court, as long as there is a reasonable relationship between the chosen jurisdiction and the transaction. So that's half of it. But there is an or in Veritas. There is an or in Friedland. Or is unjust or unreasonable. There is a
Veritas is a federal case.
I understand that, sir, but
let's cite the Supreme Court. What's binding to us?
Sure, but the Supreme Court may just not be quoting the second half of it. But there's two ways to go about it. So we've got Friedland provides an or. We've got Veritas, which one should assume is, if it's federal court, it's federal procedural, but state substantive law is what they would be applying. They're not applying a federal statute. There's an or in there. Unjust or unreasonable is part of the test. But let's go back to Your Honor's concern on strong public policy. There has got to be a reasonable relationship between the jurisdiction and the transaction. That comes out of this court's decision.
Before you, can I just interrupt you with a question? You're trying to argue unjust and unreasonable as in the alternative, correct?
Yes.
Okay. The trial court refused to give you a ruling on that. I don't want to get into that. So the vague comment about everything's preserved for the record, I'm not sure what that is saying on appeal, but you normally would go back on a rehearing and say, Judge, can you put that in writing so we all understand it? Was that done in this case?
I guess I'm not understanding the question. The trial court refused to make a ruling on the second half of that, on whether or not it is simply.
But how do we second guess the trial judge saying, I'm not going to make a ruling, and you didn't go back for a rehearing to say, Judge, you got to make a ruling so the appellate court can review this?
Well, on remand, that's what it would be. On remand, you would say you have to decide, and this court should tell us, is the test an or not? If the test is not an or, if Veritas is wrong and Friedland is wrong, somebody needs to say that. This is not a two-part test. This is a one-part test. It's strong public policy, yes or no. If that's the law, that's the law. If it's not the law, then the trial court, who I already pushed on the point, there's no reason to think that a rehearing would change that. I argued Veritas. I argued Friedland. The trial judge didn't want to hear the or piece. So
did you have a state court case that you were arguing to the trial judge, or just the federal court cases?
Well, it's both. It's Friedland. Friedland is quoted by Veritas. So that is the Florida, that's the third DCA from 2008 quoting Veritas. So we do have both. And I do believe that's a two-part test because at least two cases say that's a two-part test. Again, if it's not, tell us it's not. This is it. It's strong public policy. But strong public policy by this court's decision in Cash Call versus Office of the Attorney General says that there has to be a reasonable relationship between the chosen jurisdiction and the transaction, and there's not in this case. And the way we can get there is look at the Florida Supreme Court in Morgan Walton. The Morgan Walton case was talking about this exact issue from a Louisiana bank. The court in Morgan Walton found that Louisiana law should apply because Louisiana was the place of contracting, the place of performance, the state of the lender's domicile, and they noted that the borrowers went to Louisiana in search of the financing, and the agreements therefore had a normal and reasonable relationship to Louisiana. None of that do we have here, not a bit of it. And ask yourself this question: if this really is a Wisconsin case with a nice Wisconsin bank that intended to make loans based on Wisconsin law, why is there a New York venue clause in these documents? Why? We know why. Because this is a sham. Wisconsin law application is a sham. Nothing happened here. Not a single payment was made to the state of Wisconsin. Not a single payment was supposed to be made in Wisconsin. That New York venue clause, and I'm not arguing venue here, but I'm arguing that the inclusion of a New York venue clause is what shows us that this bank didn't intend to take a payment, didn't intend to service a loan, didn't intend to do anything with this, because they included in there a New York choice, and we know that. So when we look at Morgan Wallen and we see what happened there as to why Louisiana law was correct, it's because it had a reasonable connection to Louisiana in that point, and the Florida Supreme Court said that's good enough to apply Louisiana law. Those are not the facts that we have here. There is no reasonable relationship between the chosen jurisdiction and the transaction, and that is absolutely required before we decide that Florida has no strong public policy against usury. There's no debate on that. So there's two things you've got to consider is there is an or out there from Veritas. Is it unjust or unreasonable? We know that it is. Florida would tell you if this was cleanly a Florida case, this is criminally usurious to charge 80% interest. Criminal usury in Florida starts at 45%. Civil usury on this amount is between what's over 25%, and it's illegal over 18%. There's no debate anywhere that if this was under Florida law, this would be an outrageous interest rate. It would be a criminal interest rate. That on itself makes it unjust or unreasonable in line with Veritas and in line with Friedland. There's no reasonable relationship of Wisconsin to any part of this transaction. And because that is so, this case needs to be remanded to the trial court to at least make the determination, the factual determination of whether or not the interest is unjust or unreasonable in this transaction. Alternatively, this court can simply provide that the or isn't there and at least clarify the case law on that point. But this is a usurious transaction. Florida law should apply to this case. And I would respectfully request that your honors remand this case back to state court so they can at least consider the unjust or unreasonable component. Now, alternatively, we put in the brief, and I intend to argue that there has to be a modification to existing law. 80% interest is outrageous. It's outrageous. The state of Florida already thinks that after 45%, people should start going to jail. We know it's outrageous because they've already made that fine.
I don't want to interrupt you. I just want to tell you, you're coming up to your 5 minutes if you want to save it for a rebuttal.
Thank you, sir, and I appreciate that. We know that this is an outrageous interest rate. Everyone knows this is an outrageous interest rate. The state of Florida legislature would tell you that this is an outrageous interest rate, and you don't have to allow it to pass. So I would respectfully request that you reverse the trial court's ruling and remand this back for further proceedings.
All right, I'll save you full 5.
Thank you, sir.
All right, now, Mr. McKay, now it's your turn.
May it please the court. My name is Jonathan Sykes, and I represent the appellee, World Business Lenders, LLC. The loan documents contain an enforceable choice of law provision that we've just discussed that says that the contracts are governed by Wisconsin law. There is no dispute here that the interest rate under the loan documents is permitted and not usurious under Wisconsin law. In fact, the appellant in his brief at pages 7 and 11 concede this fact and say that application of Wisconsin law is called for in the note.
Well, let me just interrupt you, Mr. Sykes. Sorry for calling you McKay before, but how did the trial judge not make a ruling on Mr. McKay's request that it was unreasonable or unjust, that it just kind of glossed over that?
Because the trial court recognized that that is not the correct legal
But
standard.
did the trial court actually say that?
That's exactly what we argued, and I believe that that's what the trial court
The only
held.
reason I'm asking, having been a trial judge, when you say something like it's well preserved for the record, it's almost like you're saying you don't need me to say that.
But, Your Honor, my recollection from the trial was that Mr. McKay and I were arguing two different legal standards, and the trial court agreed with my legal standard, which is what the Florida Supreme Court has said in three different decisions: Mazzoni Farms, Sailboat Key, and Morgan Walton. In all three of those cases, the Florida Supreme Court said that courts must enforce a choice of law provision if the contract has a reasonable or normal relation to the choice state and does not violate a strong public policy of Florida. None of those decisions say anything about whether or not the contract is quote unquote unjust or unreasonable. Certainly the 11th Circuit in Veritas and the DCA and Friedland do have this extraneous language in those decisions. But in both of those decisions, the courts actually upheld and enforced the party's choice of law provisions, and neither court evaluated or even discussed whether the choice of law provision at issue was generally unjust or unreasonable under Florida law. As
Mr.
Your
Sykes,
Honor already know,
Mr. Sykes, I've noticed the Florida Supreme Court, in the cases that you've cited, Mazzoni, Continental, and the others, there is an analysis as to a relationship. Now, this was in a Wisconsin lender at first, and then WBL buys it. They're in New York, has a Wisconsin choice of law provision. We have an Illinois resident, and this loan is secured by Florida property. Where's the connection to Florida at all? There's no payments made to Florida. There's no servicing in Florida. There's no office accepting anything in Florida. There's no business transaction in Florida at all. And I can't help but notice the Supreme Court is making that analysis. And in each case where they did apply the foreign law, it was a relationship.
you're right, Your Honor. There was no relationship here with Florida. In our lengthy motion for summary judgment, including the supporting affidavit, we put facts to support the relationship between Wisconsin and this loan. We state in the summary judgment affidavit that under oath that Bank of Lake Mills is located in Wisconsin, that Bank of Lake Mills, who was the original lender, accepted the loan documents in Wisconsin, and the loan proceeds were distributed from Wisconsin. This is Wisconsin, this is money coming from a Wisconsin state chartered bank. The affidavit also states that Bank of Lake Mills was the original payee on the note, and the appellant signed the note and guarantee with electronic signatures. Well, in response to the summary judgment motion, appellant only filed a memorandum of law and a notice of intention to take judicial notice, but filed no opposing affidavits or any other summary judgment evidence as required by Florida Rule Civil Procedure 1.510 to show a genuine dispute of material fact about the relationship between this loan and Wisconsin or any other state. The appellant makes several arguments in the brief, but none of those arguments are supported by record citations or summary judgment evidence that was presented to the trial court.
Are you saying this is a so-called mail-away closing done by DocuSign? Your client wasn't required to go to Wisconsin to sign papers?
Everything was done, my understanding with respect to the note and guarantee, which are the only loan documents at issue, everything was done remotely. Those two documents were signed electronically.
I got you. All right.
So appellant argues, for instance, that Wisconsin is not the place of contracting, Florida is. But to the contrary, the summary judgment evidence, the only summary judgment evidence, says that the loan was signed electronically and was accepted by Bank of Lake Mills in Wisconsin, not Florida. Appellant argues that the property that secured the debt was located in Florida, but this is an action on the note and guarantee, not the mortgage. Appellant also argues that the lender's domicile is New York, but to the contrary, the summary judgment evidence shows that the lender is Bank of Lake Mills, which is located in Wisconsin. Appellant argues that the payments were not made to Bank of Lake Mills. No, I think most of the payments that were made to World Business Lenders in New York, but again, not in Florida. I don't think this fact supports appellant's argument that this should be enforced by Florida law. Appellant argues that no one traveled to Wisconsin. Well, again, there's no evidence that Bank of Lake Mills traveled to Florida. In fact, appellant's notice of taking judicial notice states that Bank of Lake Mills was not authorized to transact business in Florida. And of course, the note and guarantee were signed electronically, not in person. None of the appellant's factual arguments are supported by record citations or summary judgment evidence, other than the fact that the loan was assigned by Bank of Lake Mills to World Business Lenders. But I've cited in my briefs a decision from the Fifth Circuit Court of Appeals that clearly states assignment of a contract does not otherwise affect the validity of a choice of law provision. Now, with respect to this erroneous legal standard that the court can refuse to enforce a choice of law provision just because the court believes it's unjust or unreasonable, this is coming again from the 11th Circuit decision in Veritas and a Florida DCA decision in Friedland. But as your honors probably noted, in Veritas, the 11th Circuit cites only to Friedland for this standard. And in Friedland, the DCA cites only to Mazzoni Farms for this standard. And Mazzoni Farms, which is the Florida Supreme Court decision, in that case, the Florida Supreme Court nowhere even mentions an alternative legal standard of whether the contract is unjust or unreasonable. And I think the other big problem with this standard in this particular case is that whether or not a choice of law provision is unfair or unreasonable is, in essence, a factual question that can only be answered with record summary judgment evidence. This was a case filed in 2018. We did extensive discovery. We filed a lengthy motion for summary judgment addressing every single claim and defense in this case. In response, no summary judgment evidence other than a notice of taking judicial notice was filed in opposition to that motion. The only grounds cited by appellant, both to the trial court and this court, for the argument that the choice of law provision is unjust or unreasonable is that the interest rate violates Florida law. In other words, the appellant makes the circular argument that this court should refuse to enforce the choice of law provision for Wisconsin law because the contract would be unjust or unreasonable under Florida law. This would completely upend all jurisprudence in Florida on the enforcement of choice of law provisions. Courts should not have the discretion to refuse to enforce contractual choice of law provisions based only on whether that contract would be unjust under Florida law, where the parties expressly chose to be governed by the law of a different state, in this case, Wisconsin.
All done?
Thank you, Your Honor. I was just reviewing my notes.
No, go right ahead.
I do respectfully request that this court affirm the trial court's judgment and award of appellee its appellate attorney's fees and costs. I'm happy to answer any additional questions that this court may have. Thank you.
Thank you. All right, that brings us back to Mr. Sykes. Mr. McKay, you got 5 minutes.
Thank you, Your Honor. We can't ignore the word or, and opposing counsel desperately wants us to, but Veritas didn't invent the law on this subject. Friedland didn't invent the law on this subject. They put an or in there. The or has meaning. It's not surplus. We've got to read the or. And Viridius is a 2018 case that is purportedly stating state law on the subject. There is an or in there. It either contravenes the strong public policy, and to do that, there would have to be a reasonable relationship to the chosen jurisdiction, or it is unjust and unreasonable. You can't read around the or. That's the test. Now, the state court refused to read the or piece of this, and there would have been no sense in me moving to rehear it. I presented the argument to the trial judge, and the trial judge evaluated it on public policy, but refused to evaluate the unjust or unreasonable component. I preserved it.
Why are you limiting the relationship to the other venues and forums just to public policy? I don't believe the Supreme Court did that. When the Supreme Court looked at unjust and unreasonable, they also did the relationship analysis. I do not believe the relationship analysis is limited only to public policy. Tell me where that is in there, where they make that differentiation of, okay, now we're going to look at the reasonable relationship under the unjust and unreasonable analysis versus
Well, they
public
don't.
policy.
Right. The reasonable relationship between the chosen jurisdiction and the transaction only relates to the strong public policy component. And that comes right out of the second DCA and cash call. That says that Florida has no strong public policy against usury as long as there's a reasonable relationship between the chosen jurisdiction. That's the public policy argument. The rub is that, and this court didn't address it in the cash call case, but there is an or there. And the or is cited in Viridius in 2018 that the 11th Circuit thinks there's an or there. Now, the trial judge didn't, because the trial judge didn't take up my invitation to rule on that, but it's there.
But the trial judge ignored and rejected Viridius. He did make a ruling. He
That's correct.
rejected Viridius.
That's right. And that was an error. And,
Okay.
and the trial judge even said that issue is preserved for appeal. And here we are. If there's not an or there, and maybe there's not, it's in the cases though, it says it. But if the test is not an or, I would respectfully request you to say that. Say this isn't the test. Say Viridius got it wrong. Say Friedland got it wrong. At least we know. But as we sit here, the 11th Circuit, quoting state law, thinks there's an or there. And there is an or there until somebody says there's not.
But what evidence did you put into the record to support your argument? What evidence?
What evidence? That it's an 80% interest rate.
That's it?
How much more do you need? It's criminally usurious, Your Honor. 45%, it turns into a criminal matter. How much more do you need to figure out that this is unjust or unreasonable than the Florida legislature saying 45% is criminal usury? That is a factual question. Now, maybe the trial judge looks at it and says, oh, that's not unjust or unreasonable. But we weren't given that chance. And those are the facts, and the trial judge refused to consider that. If for some reason the trial judge wants to say that that's not unjust or not unreasonable for some reason, let's invite him to do it. But we didn't get that chance, and that is the test. And respectfully, if it's not the test, tell us that's not the test. Tell us that Viridius is wrong. Tell us that Friedland is wrong. Or certify conflict with Friedland and say there's a conflict. The Supreme Court thinks there's not a two-part test. Friedland and Viridius thinks there is. Somebody tell us. But when I see the or, I think unjust or unreasonable is the second piece of that. So it's strong public policy, which requires a connection to the chosen jurisdiction, which isn't there, or it's unjust or unreasonable. And I would suggest to Your Honor, certainly the strong public policy is a harder argument for us because it's been ruled on a few times. I would still suggest there was no reasonable relationship, but it's the or is unjust or unreasonable. And you don't turn existing case law on its head if you find that. It just allows the trial judge to say it is or it's not unreasonable. I invited the trial judge to at least do that and make the finding, even if he wasn't ruling that way, so we would know the answer. But I would respectfully suggest that it's got to be remanded for the trial court to determine that. So for those reasons, I respectfully request that Your Honors reverse and remand at a minimum for the trial court to make a finding that this is unjust or unreasonable. I'm happy to answer any further questions, Your Honors.
Well, you're technically out of time, but if there's questions, I'll wait. All right, it looks like there's no questions.
Thank
Thank you,
you.
sir. Gentlemen, both argued well. We'll move on to the next case, which is the City of Tampa versus Frederick.